All right, we're going to go ahead and get started because I think there are a bunch of folks that want to be at rules at 11. And so we're going to try to move as fast as we can, but give everything due consideration. So appropriate. Okay. Well, I don't know. It's sort of like I want mercy, not justice. I don't know that we want appropriate. Chairman Willard, let's start with you. Tell us about your bill.
Good morning, ladies and gentlemen. I'm here with Representative Wilkerson, who's the co-sponsor on House Bill 41. As I mentioned the last subcommittee meeting, I presented to you an amendment, which is really a substitute, I should say, of House Bill 41. Concern was raised by a number of people as to whether or not this has any impact around other parts of the state. I suggest I don't think it would, because I believe everywhere else you have, by agreement between two governments, agreements that work out the rights of delivery of services beyond the boundaries of one jurisdiction into the other. For that reason, I've given to each of you this morning the provision that comes out of our state constitution. Now, I will preface what we're talking about here is this is not a maybe or something. This is a mandate. This is saying that if you look at under paragraph 2, it starts out, of course, unless otherwise provided by law. Number 2, no municipality may exercise any of the powers listed in subparagraph A, and that's not on here, but that's all your what we call home rule powers. It covers practically anything that may be a service provided, and it includes water, it includes sewer, it includes trash pickup, whatever it may be. But all these listed, enumerated home rule powers that each city and county has by constitutional provision. And says none of those powers listed in subparagraph A of this paragraph or provide any service listed therein outside its own boundaries except by contract with the county or municipality affected. Now, to say this is a mandate, it's not something suggested, it's required, so that you don't have a duplication of services, number one, but also for one government to have the opportunity as an enterprise to perform a service beyond its boundaries, whether it be a county into a city, or a city into the county, or the city into another city, requires there be a constitutional contract, we'll call it, to authorize that service. The city of Sandy Springs was created in December 2005. Since its creation, we have tried to talk to, negotiate with, meet with Atlanta on the basis of discussing with them the fact that they provide water into the city of Sandy Springs, and for which there, to my knowledge or anyone else's knowledge, there never has been a contract. But there has been apparently the opportunity given previously by Fulton County to allow Atlanta to expand that system into what was then the unincorporated areas, and then with the incorporation of the city of Sandy Springs, in order to have our city government answerable to our people, of the 99,000 people who live in Sandy Springs, we felt it important that there be a contractual agreement between Sandy Springs and the city of Atlanta. We've called for meetings with them. We've gone to meetings, and the only response we get from the city of Atlanta is no. Period. We're not going to talk to you about it. Well, to me, it's in violation of this constitutional provision. Now, we are in currently negotiations under a service delivery strategy agreement which would cover this. But again, they have objected to anything being put into the service delivery strategy addressing the authorization of delivery of water outside the boundaries of Atlanta into the boundaries of the city of Sandy Springs. In addition, they charge, you hear and read stories about Atlanta having the highest cost of water in the country because they're using the combination of their water and sewer fees into what they call their water management program, and thereby they're able to take fees for the cost of their water. They charge for the fees and use that as a pool out of which they're now also building their sewer system. And as a result of, over the years, this need to repair substantial costs, running close to $2 billion, I believe, repairs and renovation of their sewer system, they have raised their water rates substantially. And then I'll say, we're the highest, one of the highest water systems in the country. I say, no, you're not. We are, because Sandy Springs is required to pay a 21% premium on its water services that we receive in Sandy Springs, provided by the City of Atlanta. I'm suggesting that because they will not enter into a contract, the appropriate thing for us to do is recognize that if they won't have a contract, that they may be limited to being able to at least charge the people of Sandy Springs more than they charge the people of the City of Atlanta for water. So therefore, you have under 2.1, this is under the Service Delivery Strategy Law, and the first paragraph, 2A, governs the current law, and it provides that there can be a higher charge only if the charge itself is not arbitrary rate differentials. Well, we think there is. But we can't even get them to negotiate with us. That's the problem. So we're asking for this committee to recognize under 2.1, I'll read it, the strategy shall provide that water or sewer fees charged to customers residing in political subdivisions created on or after January 1, 2000, located outside the geographic boundaries of the service provider, shall not be higher than the fees charged to similar customers receiving such service which are located within the geographic boundaries of the service provider unless otherwise provided by contract between the service provider and the governing authority for the affected county or municipality outside the geographic boundaries of the service provider. Simple as that. So if they want to continue and not sit down in good faith, work out agreements with the City of Sandy Springs, I submit they should not be permitted, which they're doing under this paragraph 2B, to charge a higher fee because there's not a contract in place. And this would at least level the playing field, and I submit to you it is fundamentally fair that this particular provision of the law be changed. That, Mr. Chairman, is my presentation on the bill.
All right, let me ask you a question. Understanding your level of frustration, but it takes two parties to contract, and Atlanta may very well be saying, we'd be happy to sign a contract with you saying that you will pay 16% more than what a resident of the City of Atlanta pays. And you say, no, I don't want to sign such a contract. I want one that says 1% or 2%. And if y'all can't agree on that, then what your bill would do is say that they don't have any choice. They then have to charge you the in-city rate, which puts you in the position of, if I don't agree with anything, then you know it's to your advantage not to agree to anything, because that forces them to sell it to you at the in-city rate. So does this not change what you say is an unlevel playing field now to an unlevel playing field in Sandy Springs' favor rather than in the City of Atlanta's favor?
I submit it does not, Mr. Chairman. I say this because you don't have the ability now to even bring about a negotiation between the parties. And it's not just water rates, it's the service itself that's provided to the citizens of Sandy Springs. We virtually have no voice. The citizens have no voice because, let's look at other type of franchised services. Electricity. You have elected public service commission members, each of us can call up and raise cane about it if we're dissatisfied with what's being provided either by our electrical provider or our telephones. If you live in a rural area, you got EMC boards, you got people who are responsible to you as a citizen receiving that franchise service. The citizens of Sandy Springs have no one that they can go to, and in fact, as repairs are required, as bills if you read about stories of the horror stories of some of the bills that have come out, we've got citizens who have been extremely put into a bad position because of bills that were way out of line as to what was actually being done, and not have anyone to go talk to as far as elected officials, someone responsive to them. Now, what I'm suggesting is, to get back to your question though, what can Atlanta do? Well, they say we're going to cut off your water. I don't think so. But if they say we're not going to give you water, we've got other suppliers of water that we can turn to that will be able to provide services of water supply to the city of Sandy Springs. So I suggest there is a need for a means to compel them to come sit down and at least start talking to us so we can have these things worked through. At this stage, there's nothing to incentivize Atlanta to do that.
Well, I understand the desire to do that. My question is, are we changing the tilted level, unlevel playing field to a tilted in the other direction? Because if they will not negotiate, or if y'all will not negotiate, what if we pass this and it's signed by the governor, and Atlanta comes knocking at your door and says, we're ready to sit down and talk, and you say, only if you will charge us 5% less than what you charge inside the city limits. And they say, no, we aren't willing to do that. Then you say, okay, well, that was our deal, so you are now required to charge us what an in-city resident paid. I mean, does this not put you in control then?
No more so than I'll speak to our Forsyth friend over here, Forsyth County and Cumming. They've had issues going on for some time, but there were, even between those parties, with differences that were finally worked out by negotiation, because there's a benefit to both sides to get it negotiated and resolved. And I say this is true with every time you have had a contract around the state, Mr. Chairman, where one governing body is supplying a service or product to another governing body. There's a contract. So the parties have a beneficial interest from both sides to work out something. Eventually, they work through it. And I suggest the same thing here.
And I understand, but you know, if perhaps if it had been done the way that you feel like it should have been done, before the service had even been extended, there would have been a contract and everybody would have known where they stand. But now we've got a service that has been extended. So if you cannot negotiate a contract, do you have an objection that they can terminate water service if that's unsatisfactory?
If that's part of the negotiation, we can't reach an agreement, that's a choice they have to make.
I mean,
but I suggest we do have, staring at all of us, the constitutional obligation, and there is nothing else provided by law authorizing Atlanta to do this.
Okay. Who's 23? Okay. Representative Hightower.
I pressed my button before you really got into your explanation. My concern's the same. I've had two city managers in my district that their concern is the same as Chairman Pyle's. They provide services outside their city limits, and their concern was, Dusty, we have set revenues that we know are going to be based on these issues. If they feel as though they have an unfair advantage, why would they just not lock down, and now we're forced to provide this service for the same price we're doing for our cities? And I've had both of them call, and they were very concerned about this bill flipping.
It won't affect them, Representative Hightower.
Because their contract's already in place?
No, sir, because this second provision I'm talking about only applies to the creation of municipalities or local governments since 2000. Okay. And there's only been, I think, 7 or 8 cities created since that time. I go through a name over it. It's only those that are up northern part of Fulton County and northern part of DeKalb County that are directly affected by it. Nobody else is affected.
Representative Fleming.
Thank you, Mr. Chairman. Chairman, we have, what percentage higher are they hitting you for now?
21%.
Okay.
Was higher than that at one time.
And the way I saw this is that we have a little bit of a unique position here, although we've had, I think you just said 7 cities created in the past few years. With the 400 or 500 cities we have in Georgia, it's pretty rare, basically. Yes. And because your bill only affects basically those few cities and those created going forward, usually when you have a new city created or water extended to a different area, let's put it that way, that makes more sense. it's not extended until you have an agreement, a reasonable agreement. If both sides can't come to an agreement, then you just don't have water extended there, and they have to do something else. In other words, it's a meeting of the minds.
Correct.
We have a unique situation here where there was no meeting of the minds because the city was created after water was already in that area.
That's right.
And so you had to deal with it as best you could. Particularly given the fact that we don't create cities that often by comparison to how many we have at least, it seems to me that what you've come forth with is a reasonable proposal. And I would say to Chairman Powell, if he's, I heard his concerns, and you know, I like the bill the way it is, but if we had to compromise somewhere, what if we put a provision in that says that you can only be 5 or 10% higher than the people that are inside the city? You know, I don't want to see the bill stop because of that, but that's a possible solution. I think you can easily insert some language in here to do that. I just throw that out as a possibility.
Well, the problem with that is that the way the Service Delivery Strategy Act is done now is it says that you cannot arbitrarily charge more to an out-of-city resident than an in-city resident. And 10% may be arbitrarily high in some communities, or, you know, in some of these 6 or 7 cities, if there are. But it may be unreasonably low in some other community. But the way the bill's drafted is that if there is no contract, then you've got this fallback position. I mean, I would rather see something that said that if they can't reach it, then reach an agreement that you can terminate service in 30 days upon the breaking down of negotiations, but something to the effect of somebody is not forced to furnish a service at what they consider below market or below cost. And I don't even know what the cost is. But I'm just saying that right now the table is shifting in the other direction, and there needs to be something that makes it level. I don't know what that something is, but there needs to be something that makes it level.
What are the teeth behind the enforcement of an arbitrarily high amount right now in the service delivery strategy?
Well, I mean, right now, Atlanta serves them and charges whatever they want to. Under the Service Delivery Strategy Act, they can say that they think that this is arbitrarily high, and they can force it to mediation. There is a mechanism now, but if this bill's passed, that mechanism goes away. It's either have a contract or charge us an in-city rate.
And maybe the question will be back to the Chairman Willard, that is not working for y'all, obviously. What's keeping that forced mediation from working?
Well, I say it's still in litigation, but they're not willing to have any change to that part. I say the service delivery strategy is in litigation. As part of the next step, it goes to a judge, but that is not meaning that something's going to be resolved ever about it, except by the law that authorizes it. Makes clear that these type of fees are not going to be permitted unless there is agreement between the parties. After
the mediation that Chairman Powell referred to, is there a next step where a judge can formally come force the two parties into a reasonable number?
I think the judge can find that it's arbitrarily high, can't they, and make a determination of what's reasonable.
It takes a separate lawsuit.
But there is a mechanism now.
And we've tried to do that with regards not to the lawsuit, but with regards to the fact that we've had the study made, the rate study done by qualified engineers. Our water doesn't come from outside the city per se. Our water comes from a plant that is owned jointly by Fulton County and the city of Atlanta that is north of us by the Chattahoochee River. It actually comes down passing through the city of Sandy Springs to get to the city of Atlanta. So it's not a matter of charging greater because of a disproportionate cost in delivering the service. It's actually, I'd say, a cheaper service, but that we can't get them to look at.
Representative Hamilton? Okay. Okay. Representative Taylor?
Thank you, Mr. Chairman. This seems so specific for just your area. I also have been contacted by my local folks, and it does seem like there's got to be a better remedy. Shouldn't this be in some type of a local legislation as opposed to something that is going to affect the entire state when it's a confined area that seems to have this problem?
And you can't do this because it's under general legislation now,
Mm-hmm.
and the service delivery strategy agreement language is general law. Therefore, we can only do it by modifying of the general law, but we made it very limited and specific, so you can go back to your governance and say, it won't apply to you. It doesn't apply to you.
We don't have any new cities today, but what if there were to be a new city? And again, our rural areas, they may want to develop. Who knows that a subdivision may one day want to become a city. So again, it seems like we're doing a lot for this confined area where folks just cannot find a way without suing each other to solve a water problem.
What?
They can't get everybody to the table.
Well, we try to get to the table. That's my point. We have tried, Ms. Taylor, to get us to the table time and time again. I think the city representative came to see me and said, well, you mentioned we won't talk to you. Well, we had meetings. I said, yeah, you have meetings, but the meetings, this Atlanta's position says no. When you say no, there's no negotiation. That's the problem. If they won't negotiate, how can we otherwise get them to accept and understand the rights of the people in Sandy Springs to have a voice in what's being done, just as your citizens of a city have a right, if the county is delivering a service inside there, they have a right to voice through their elected officials who make a contract how those services are provided.
And they do. And
Yes,
when they
right.
don't like them, they've replaced people on boards and commissions.
Good point. But we have no voice to replace Atlanta City Council.
Okay. All right, thank you.
Thank you, Mr. Chairman. Chairman Willard, normally those of us from the rural areas, we sort of look after our own business and let you folks in the metro areas look after your own. The only problem is this tends to bleed over sometimes in principle, but as I was listening to what Chairman Powell was saying, it would make sense to me that if we amended this bill to put parity on both sides of this issue by making a requirement, changing the language in this to make a requirement that both these parties will come to the table and negotiate a contract. If it can't be negotiated, let it go to a third-party arbiter to negotiate this contract, binding arbitration. Would you have an objection to that language?
Now, I don't have an objection. I think Mr. Powell, Chairman Powell, will recognize there's a difficulty you face with requiring, it's a constitutional provision, a constitutional limitation, I think it's a better word, that you really cannot bind local governments or governments by arbitration. It has to be really the elected officials who make the ultimate decisions.
Well, didn't we do baseball arbitration?
I said, but you do have baseball arbitration, which is where the parties have agreed to submit and be bound by what a court takes as two proposals and accepts one of them. Now, following up on that, let me say there's a challenge now ongoing to that provision, as say Chairman Powell, smiling from ear to ear, coming out of South Georgia, I think out of Valdosta, Lowndes County, to whether or not the provision that we have under baseball arbitration is or is not constitutional for that very reason. I'm fine to say baseball arbitration, but I think the question now arises, I would prefer maybe doing this, say that the parties will either agree this would not be done until there's a notice given by one party and the parties sit down and negotiate, and failing to reach an agreement, then in 180 days or something, they would come to this triggering provision about the rates. Just give us some time to talk with it. Open up your heart to us and let us talk with you. But
don't have a problem opening up my heart, but I'm sitting here and I'm thinking, and I understand what you just said, and I think that's the start of the possible amendment. But what if Sandy Springs they call for negotiations, and the city of Atlanta says, all right, the jig is up and it's time for us to step to the table. Well, then all of a sudden Sandy Springs decides we're going to just stonewall this.
Well,
and then at the end of the 108, and at the 100, but two wrongs don't make a right. Mm-hmm. And but to bring it up to that, so and put up certain language so that there's got to be an arbitrator somewhere in here. We've been doing this. The General Assembly's been doing this for decades, of bringing up necessity of arbitration.
It's not looking like rules is real positive here.
Thank you, Mr. Chairman. I just say real quickly, since the chairman brought up Forsyth County and Cumming, that's exactly what happened. Is they had expiration of a contract, could not reach a general consensus, and so both sides agreed to go to non-binding mediation, and the mediator made a suggestion, and then they turned around and accepted that, and that ended the situation. But I think in our case, it took a independent party that was able to take the emotion out of it and come up with the ultimate solution.
Which I guess begs the question, because all of that mechanism is, as I understand it, is in the Service Delivery Strategy Act. And so why is it that if we're going to wind up either mediating or arbitrating this, if the parties cannot reach some kind of agreement, why is it that the Service Delivery Strategy Act won't work or is not working?
Has not worked to this point in time. Only last November did we come out from under a federal court decision that was brought by Atlanta to bring us into their federal litigation where we did not belong, but the judge, district court level, maintained we were going to be in that litigation. We appealed to the 11th Circuit Court of Appeals, and they agreed we didn't belong in that litigation, and the decision came out last November. But that took us about two and a half years to get resolved that way. And I say this has been ongoing prior to that, talking, wanting to have conversations and nothing getting done. It's just been 7 years of it, and it's frustrating to the governing officials of Sandy Springs that we cannot have an opportunity to speak openly and with say a level field of negotiation. We don't have a level field now because we have nothing that says contract-wise you're not complying with what you're required to do. It's a very unusual situation, I agree, Mr. Chairman.
I understand.
I'm trying to find some way to say, City of Atlanta, meet with us and do the right thing.
Okay. Any other questions from the committee? We've got one party who has signed up to testify from the City of Atlanta, and Megan Middleton. Y'all can stay where you are. She's going to stay at the podium.
Good morning, members of the committee. Megan Middleton. I do represent the City of Atlanta, and I'll start out by saying we have been trying to work with Representative Willard. We have had discussions as far as trying to work through what we can. I wanted to state on the Georgia Constitution article that Chairman Willard addressed. There was one section as far as his statement that there's at the end of that statement is that what you can and cannot do. There's a wording that was at the end that says unless otherwise provided by law. So we're allowed to do this by our city charter. That's the law that gives us the authority to charge a higher rate for this service. I just did want to point that out. I also wanted to just basically go over, like you have stated, that the Service Delivery Act already has a process in place, and it's been in place since the 1990s when the General Assembly passed this act. If citizens don't think that they're being charged correctly, they think they're being charged a rate too high, they can call for a public hearing. The next step is they have to do a rate study by a qualified engineer. If that does not bring the parties into agreement, the next step is to go to submit to alternative dispute resolution, and that is part of the process right now in the Act. If that does not, clarify the issues and let the parties move on, then the next step is to go to court. In 2000, some of the citizens of, at the time, unincorporated Fulton, which is now Sandy Springs, did go through this process. They, stated that they were being charged a rate that was arbitrarily high, that a rate study was done, and that rate study did show that Atlanta was charging 42% higher rates, and it really should be at 21%. So at that time, Atlanta lowered their rate to 21% outside the city's rate, and that has been challenged in court and has withheld a court challenge, and that is where we are now. I do respect the chairman, saying that we want to get the jurisdictions together to discuss this, and it has been discussed, but it's just one of those things where the parties just cannot agree. We agree, we have that, or we believe that we have the authority to charge the higher rate based on the science, which is what the rate study was. that there are expenses that come with one jurisdiction providing service to another jurisdiction. You have other liabilities that you have to take into account. So that's why a rate study is done to prove that, based on these things that you have to go through, you have the authority to charge a higher rate. This is done throughout the state of Georgia. This is not something new to Atlanta or the metro area. This is also something that is done throughout the nation. So once again, it's always backed by rate studies. There's science behind this. Again, we have been challenged in court, and we have it's always been upheld. It's just a rate that we're just not agreeing to lower because we have additional expenses to provide this water. One thing that I wanted to mention too is that when Sandy Springs was incorporated, the Service Delivery Act already existed. So newly incorporated areas knew what the process was for when you get service from another area. Our contract, or we don't have a contract with Sandy Springs because Sandy Springs does not have a water system. They don't have any pipes that we can, sell them to as a wholesale customer, as a city, and that they could then have retail customers. The city's pipes are what are in Sandy Springs, and our customers are it's at the retail level. So it's the houses, the businesses, they're in that section of Sandy Springs that we deliver water to, and those are our customers. That is why it wouldn't be appropriate for us to have a contract with Sandy Springs because the Sandy Springs jurisdiction does not have a water supply source, so they don't have the pipes to deliver water. This is, like I said, this is something that we've been, going back and forth on for quite some time. Respectfully, we just can't come to an agreement on a lower rate based on the rate studies. This is something that we have had historical contracts on. We actually do have the contracts that show that Atlanta went into a contract and was asked to build out their system to go through and up north into parts of Fulton County. And we've done that in other areas. And so we do have these agreements with Fulton County from previous years. We've been serving outside the city's jurisdiction since 1917. And we have the agreements that say that, please do this, here's a contract, build out the system. We need to get water moving in other areas. And so we've been doing this for almost a century now. So again, we do believe that there is already a system in place. Sandy Springs and other entities, other incorporated areas, knew about this system and this process when they became incorporated. There is no water. They do not have the pipes available to deliver to Sandy Springs as a customer. We do service those retail customers.
Let me ask you, from the standpoint of Atlanta, I mean, we've got the Service Delivery Strategy Act now, which at best is cumbersome and time-consuming. Obviously, the city of Sandy Springs and their residents are somewhat frustrated that this has been going on for 10 or 12 years and no resolution. And, of course, I understand that there was a rate study done some time ago, which resulted in the lowering of the rate from 42 to 21%. But Sandy Springs says it's time to do this again, but we aren't getting anywhere. So there's a level of frustration that exists now. I don't know that the bill that's been presented to us is the answer, but if there has to be a bill, is this something that you can deal with? I mean, it basically, as I see it, and I may be reading it wrong, you either have to enter into a contract and negotiate a contract, or you have to furnish them water at the in-city rate, or if you aren't willing to do that because you say your cost is higher than that, I guess you discontinue service. Is that the option? I mean, is that something that if this bill were passed and if y'all had a stalemate and could not reach an agreement, would you be prepared to terminate service?
That is an option. All three of those are options, and that is an option. We are prepared to even amend the bill to add language that would not require us to provide service if we cannot come to some agreement, and would also state that we would not have any liability for not providing that service. So, I mean, we are, in talking about language, we have, you know, that is a possibility. I won't say definite, but it is a possibility.
Questions from the committee? 26. Representative Fleming.
Thank you, Mr. Chairman. Ms. Milton, the 42% rate that you were charging before, I guess the court stepped in and made you change that. It's what it sounded like. Somebody made you change it, cut it in half, right?
Yes, after the rate study was done, we agreed to lower it
Okay.
without the courts.
The 42%, where did that come from? Was that an agreement with Fulton County prior to?
I actually cannot state that, but I can find out for sure. But it was something that was being charged. Maybe it was an old rate study. I really don't know that for sure. But once the rate study was done, we agreed that it should be lowered to 21.
Okay. Thank you.
I can find that out.
Any other questions?
I'd like to respond when you have a moment, if I may.
Don't go away. Yes, sir.
Well, let me first go back and state something I said earlier, too, and that is realize that what we're also encompassing with the fee structure in the city of Sandy Springs is the payments through the water fees going into their watershed fund, the cost of rebuilding their sewer system, which we do not have any participation in. So when you talk about the rate structure, that is a major issue to it that we're not able to get them to sit down and talk about. Yes, the old rate, we don't know where it came from as far as the amount. I think it was just an arbitrary rate that they had signed, but that came prior to the time that the city of Atlanta had combined their sewer funds and their water funds into one enterprise fund. That's what they've done now. A contract, she mentioned, I've asked for years to see whatever they've got as far as a contract, and nothing has ever been shown to me of a contract. So if they've got a contract, please, Ms. Middleton, ask your city officials to furnish me a copy of that contract so I can see what it says. It may be that we're bound by that contract as a successor city. I don't know. But they should, at least if they're going to argue the contract, provide that to the people who asked for it, who are under the I'll say their contention of control of that contract. Third point is, I was trying to think what it talked about the fee structure. Oh, I know it was. They claim the legal authorization. All they've got, Mr. Chairman, members of the committee, is like so many charters have, is that a city may be authorized to provide a service outside its boundaries. It doesn't mean that they are now permitted. When you just say you're authorized to do it, doesn't mean you're permitted until you have what is the mechanism under the Constitution, an agreement with that government. So just authorizing your ability to go outside doesn't mean you're now permitted to go outside.
Any other questions?
And I'm not sure that this is something that anybody in this room can answer, but even 21% higher than what you're getting in the city, is that? Are there other jurisdictions in Georgia that are being charged that high, or is this an outlier? Or?
Oh, yes.
Really?
Yes.
Okay.
Much higher.
Okay.
Of course,
Thank
in
you.
Atlanta's case, their rates are higher to begin with, so 21% may make it 3 times higher than anywhere else in the state of Georgia, but there are some communities that maybe charge 50% or 60% or 70%. And part of the Service Delivery Strategy Act was to bring some kind of rationality to it, because at one time it was pretty much a standard practice that you were charging a rate outside the city in lieu of taxes. And so that was the rationale for it. And then the Service Delivery Strategy Act said, no, there has to be a rational reason, a rational basis for a higher differential.
Okay. Thank you.
Do you have some suggested language that you want this?
I do have suggested language for the substitute.
If we're going to do something, It may be we're going to study it some more, but we're going to do something. And if you got something you want us to consider, you need to hand it up.
Okay. And I can just, do you want me to summarize that, or you?
All right, the highlighted yellow is the addition to the substitute.
I'm sorry.
The highlighted in yellow is the addition to the substitute.
Yes, sir.
All right, Chairman Willard, since you don't have the benefit of this, I'm going to read it. At the end of the language that you had for cities created after 2000, et cetera, provided, however, in cases where no agreement is reached between the service provider and the affected governing authority, the service provider shall have no obligation to continue to provide water or sewer to customers of the service provider located within the governing authority for the affected county or municipality outside the geographic boundaries of the service provider. And the service provider may cease providing service and shall incur no liability for failure to provide water or sewer service to the customers residing in the governing authority for the affected county or municipality, which basically is the same thing that we were talking about. But it addresses, I don't know if it's the ideal solution, but it addresses my concern about the playing field tilting the other direction. There has to be something, if you can't reach an agreement, that you cannot force them to provide the service at what may be below cost.
I think that's a matter of law.
Yeah.
I don't
So
think it's right, but you got it.
do you have a problem with that
I don't have
amendatory?
a problem with that.
Okay. All right. We spent a little bit more time than I anticipated on this since there'd already been one hearing. What's the pleasure of the committee? $26.
Move to pass.
On the committee substitute?
Yes, sir.
Okay. There is a motion do pass on the committee substitute, which is the one that limits it to cities that were created after 2000. Is there a second? There is a second. All right, now discussion. Are there any amendments? Are there any amendments? Somebody want to offer it?
If you want it, Mr. Chairman, I'll offer it.
Okay. The Fleming amendment is offered. Is there a second? All right, the motion second. Discussion on the Fleming amendment. All in favor of the amendment say aye.
Aye.
Any opposed? Passes. Now we are dealing with the bill, the substitute as amended. Any further discussion? Call the question. All in favor of the substitute as amended, say aye.
Aye.
Any opposed? It is passed to full committee as amended. All right, Mr. Hamilton, another short bill.
Thank you, Mr. Chairman. I bring in House Bill 228 for its third hearing in subcommittee. Have a sub, LC 286625S. Without being redundant, let me tell you what this sub includes. This sub includes an additional exemption from what we put. If you look on page 2, starting on line 47, exemption number 4. That exemption basically gets into employees that are analyzing pending legislation to determine the effect of such legislation and their communication with respective agencies, authorities, bureaus, departments, office, commission, political subdivisions, and so on and so forth, including their supervisors. Also, thank you to Representative Fleming. We also put in there a little change of or similar, so it means that they can communicate. Two different water departments, as an example, could communicate with each other This additional exemption, we've tried to take every single possibility. You can never be 100% on these things, but we tried to add all those into there. I think we've done a very good job of that. I will just say that met with GMA on Friday and listened to all their concerns and feel like that we've tried to address every single one of them. I provided this sub to both ACCG and GMA. We also have changed, if you look on page 3, starting on line 64, we put on the first offense to be punished by a public reprimand. Again, my intention was never to punish anyone, but we just want to say we've got to stop this. And so this way they will be notified of this. And then the second is up to 500, the third is up to 1,000, so there is no criminal. And we've also added, if you will see down there on line 69, for purposes of this subsection, the sending of multiple communications in violation of this code section at one time shall only be considered as one violation of this code section. So I have tried to take every single objection that has been given to me and tried to include it as best we reasonably could. And then only one other further clarification, upon communication with a variety of people, it was determined that what I was told as far as the sanctions, that it would be done through state court. I stand corrected. All of this is in Chapter 5, Title 21, so it would be handled by the what I call the Ethics Commission, which has a different name that I'm not even going to try to remember. And in speaking with the executive director of that commission, she has indicated that she gets regular calls and contacts on this type of thing on a very regular basis anyway, and that this way they would know how to further clarify that. And one final comment, I have received communication this weekend from a branch of government that says that they have a professional standards commission that already has this, and it's redundant. And what I would say is it may be redundant, but it doesn't seem to be working because we continue to get those. And so that's what the committee sub does. This is the third hearing, and I'd be happy to answer any questions that any committee member might have. Thank you, Mr. Chairman.
Are there questions of the author? If there are none, we've got a couple of folks who have signed up on this. There was quite I think a fair amount of testimony before, and so there were only 2 people, I think, that may not have been gotten to before. Yeah. Margaret Ciccarelli? Ciccarelli.
Margaret Ciccarelli from Page. Thank you for giving me the opportunity to speak to the subcommittee today. My prepared testimony is basically moot at this point because the author has done a lot of work that addressed our concerns, particularly with the criminal provision, which has now been put in the realm of ethics, which is really what this is about. Just wanted to share that we didn't come speak with you earlier, and I apologize for that. The reason is because we were neutral on the legislation until that criminal amendment was added. Then it gave us concern, and so I appreciate all the work that's been done there. I want to remind everybody here, including educators who are listening, that it's important that we understand that we all need to use public technology in a responsible and ethical way. We frequently remind our members of that at Page and put that in our communications, particularly when we suggest that educators may contact their legislators. We say, remember to use your personal email account. And and remember to do that outside of class time and not from a school computer. It's part of what we do as a professional organization, at a trade organization, to tell our folks that we don't need to use publicly owned resources inappropriately. So I want to let y'all know that we understand that problem and that we want to partner with you to address it, and that we appreciate that the author has made some very smart changes to the bill. and that we look forward to working with you as time goes on. I suspect that you may have been contacted by the Professional Standards Commission regarding educators.
Is that a question?
Over the weekend, yeah, it sounds like.
Well, actually, it was very ironic because I was communicated by a educator about this very thing, and I thank them very much for their participation. Thank for them for doing it after hours. Thank for them for doing it on their own personal communication. And then they represent a certain area that I'll leave nameless, and said that their board already takes action on this and gave me all the reasons why this was not necessary. And within 15 minutes, I replied back to them about one of their local teachers had just sent me an email violating what they said was against their school board policy as well as the Professional Standards Commission. And so I said, that's exactly what I'm talking about, that they may have those policies, but from what I can tell, they typically, by some at least, are not being followed. And that was a great example of exactly what I was talking about.
Right, absolutely. And I just want to apologize for that, and I hope that that person was not sent your way by my office. And would also like to mention, just for the future, for that, in case any legislators are approached by educators who are using resources inappropriately, that the Georgia Professional Standards Commission, which issues teaching certificates to our Georgia educators, has a code of ethics that mandates that educators use public resources appropriately. Any Georgia citizen can report in writing to the Professional Standards Commission that an educator has violated the PSC code of ethics. Our educators take that very seriously, but we do have folks who sometimes violate those ethical rules, those 11 ethical rules. So I just want y'all to know about that remedy exists, and also to thank you and to say that we look forward to partnering with you moving forward.
Can I ask you a question?
Yes, sir.
Mr. Chairman, is that okay?
Sure.
Let me just bring up a situation where I was made aware of a page representative in a local school that information is sent from page to that particular teacher, and then that teacher then turns around and forwards to 300 and something people on a list. And my response was, why couldn't Page send that to their personal email address, of which they personally then emailed all those to those teachers? And I'm assuming that you would support such a thing so that it doesn't come out once again, and that Page would seek to do its job to make sure that any communication that they are doing with those people are done on their own personal emails when appropriate.
Absolutely. We do support that best practice, and unfortunately we've had educators who continue to use their professional email addresses to sign up for our communications, and I think that's because very often the line is blurred between professional development and professional practice and politics in the case of education policy. But we are moving in that direction, and I want you to have my assurances of that, and I want to work with you on that. So I just appreciate the ability to talk to the subcommittee today and have thoughtful dialogue.
Thank you.
Thank you.
Tom Gale, you signed up.
Members of the committee, my name is Tom Gale with Georgia Municipal Association. I do also want to thank the Chairman Hamilton for reaching out to us and addressing many of our concerns. I think that the criminal penalties were of a concern to us. We probably will have to work with our cities to get them to adopt ordinances or resolutions to designate the people within their jurisdictions to have that authorization to speak for the city. But he has addressed most of our concerns. I do want to just put on the radar, and this is not going to be news to Chairman Hamilton, many of our city officials have had, I guess, have not had the best response rate from the Ethics Commission, and we would like to just put on your radar. I think that there will be some concerns about the Ethics Commission policing this rather than the local solicitors or some local prosecutor who can bring charges rather than a state agency in Atlanta. who will police the actions of local governments. But again, I want to thank Chairman Hamilton for addressing most of our concerns and sharing the language with us far in advance.
Assuming that this bill were to move forward to full committee, if you want to offer some kind of language that would have a different entity policing this, you need to be prepared to do that at full committee, or assuming that it moves further at some other point. But right now, we only deal with the language that we've got in front of us.
Yes, sir, and I appreciate it. And Chairman Hamilton has been very open about discussing these issues, and we did discuss this at length on Friday. So, you know, he has been gracious enough to listen to all our concerns and trying to work with us. So he's aware of this, but I will take your advice.
Okay. Any questions of the witness? Thank you. That's all that I see who have signed up for this particular bill. So unless there's somebody who wants, yes, sir. Yes, ma'am.
Sean Adams, ACCG. I actually didn't speak last time, but was signed up, I believe, right after Marcy. So what I want to do, I want to start by thanking the chairman and author of the bill. He did work to address most all of our concerns, especially in terms of the communication department. I appreciate that. He did send us this in advance. Taking out the misdemeanor, I think, goes a long way as well. We will continue to have a concern from the penalty provision side. I do understand his desire to have some teeth in the language, so I appreciate that. One suggestion I would make would be to consider a knowingly and willfully standard or burden of proof, just to prevent those situations where somebody can grab another person's phone, make the call from it, or if someone gets called into their boss's office, doesn't log out of the computer before they walk away, another employee might have a grievance against them, can set them up for a gotcha moment. We want to try to prevent that, so if there's any desire there, I would like to just raise that to the committee's attention.
Well, I don't believe you need a knowing and willfully for somebody to use your computer. I mean, it is personal to you, and if you don't do it, then you're not responsible. And knowingly and willfully is not going to help you if you have been set up, because anyway, never mind. Okay. But I don't think that's going to help. Any questions of the witness? Thank you. Was there someone else that said that? Yes, ma'am.
Good morning, Mr. Chairman, members of the committee. My name is Tracy Ann Nelson. I'm with the Georgia Association of Educators. Just to reiterate some information, we spoke to the author of the bill early and agreed with his evaluation. But two things I think you should think about is, one, we do advise our members not to use school equipment or materials for any activity outside of work. We sign up our members through their personal email. That's what we require of them. But what's happening with some of the issues that we are having in terms of technology is, for example, in Forsyth County and Bainbridge High School, there's a Bring Your Own Technology program where the line is being grayed, between work and after work. So communication between families and teachers are happening beyond just the emails of school, but also within the personal communication format. And as we move towards, spreading that technology across the state and across school systems, we have to be cognizant about that graying line. Thank you.
Representative Fleming.
I had a question for the witness, please, ma'am.
Tracy.
Thank you for coming today. You mentioned that there's a problem because you have bring your own technology and a line graying between what's going on during school and after school. I don't understand that to have anything to do with the chairman's bill. And I guess the reason I'm asking is all he's talking about is whose computer are you using. You can do anything you want to on your personal computer.
Sure, but with the bring your own technology to school component, if an educator is using their personal laptop or iPad or whatever the new technology is at the time, they will have their personal and school emails on it. So we have to be make sure people are trained to make sure.
Just like on my laptop, I have my state house representatives and my
Right.
personal email, but I know which account I'm sending from. Is
No,
that the
so
problem?
I get it, but sometimes people make mistakes,
Oh, well, obviously, yeah.
not
yeah.
intentionally.
I'm usually
and
first in
so-
line to make mistakes when it comes to computers, but I don't see any problem with the chairman's bill and what you're asking
No,
for.
we don't have a problem with the bill.
Okay.
We appreciate that the sanctions are being reviewed, but I just want everybody to be cognizant about that graying line in technology.
Thank you.
Thank you.
Representative Taylor.
Thank you. I just wanted to talk about the same thing, because there is clearly the ability to separate when you're using your personal equipment and anything to do with these technologies. I realize they're very different, but it's also very easy to separate them, and you know when you're supposed to use school property or public property and not your own. And again, teachers should know that difference. Even with this, I represent Bainbridge. I have that Decatur County area, and I'm quite certain it would be understandable to teachers to use it when it's their own. I receive stuff on my phone, on my iPad, on my computer, and they're separated. I don't do any of my personal business on my computer for the Capitol, and I receive my emails on my personal one and answer them from there. It shouldn't be that difficult.
I'm not saying it's difficult. I'm saying that it happens, and we know
That's the
that they
problem.
get sanctions. So we want to make sure, in terms of our membership, that we make sure they know the difference and they do separate the two.
Thank you.
Okay. I want to just make one comment. The Professional Standards Commission, which we just spoke about, made me aware that if there's an issue with an educator using a school computer to send out any communication, all that has to be done is it's reported and it's investigated. I think the issue has been that it's not being reported, they're not being investigated, there's not a penalty there. So I did just want to disclose that on behalf of the PSC. And now I will turn it back over to the chairman.
Why would you just do? All right. Are there any other witnesses, any other questions? All right. Now, the Chairman Hamilton and I have been having a discussion, and I want to sort of lay to the committee what I'm thinking. Chairman Hamilton wants this bill to move. I have drafted some language as a consideration for the committee. He's not sure that he feels comfortable with the language that I've drafted, so he's requested that I allow the committee, if it wants to move the bill forward so that he can study it between now and full committee. So I am not opposed to that, but I want to tell you what the language is, what my concerns are, and also that when it gets to full committee, that I want the committee to consider this language and it not be totally vetted at that point. The concern I have is that, and this was brought up at the prior hearing, is that the initial paragraph says that that equipment, and it defines equipment, cannot be used, or publicly owned equipment cannot be used to promote or oppose legislation. And as written, what that would do is it would say that you cannot communicate internally, not only can't communicate with the legislature or with the governor, but can't communicate internally within an organization as to what does this legislation mean? Is this something that causes us concern? Is this something that will impact our mission or our ability to furnish services or whatever it is? And that concern has been brought forth to Chairman Hamilton, and he has offered part of this amendatory language that's in the substitute, which says that there is an exemption for a person whose job description includes that they can analyze legislation, pending legislation, and can communicate that within the organization. The problem is that if I send this out to department heads and say this is what the bill does, then the department heads need to look at it and they say, this is going to adversely impact the organization, and they need to be able to communicate back. So there is no exemption for them communicating back. And so the language that I have offered is basically to take out that exemption for that one employee who can analyze and disseminate that information, and just basically redraw the first paragraph that says that publicly owned equipment cannot be used by a public employee to communicate opposition or promotion of legislation to the governor or to the legislature, and then that makes it clear that they can communicate within the organization. Now, the chairman's concern with that language is that that does not prevent then or make illegal an organization from basically lobbying within the organization. Please write your legislator when you get home today on your personal email, but they're using publicly owned equipment to promote or oppose legislation. And it's a legitimate reason, but I just don't know that without making this bill 10 pages that we can come up with every scenario that is acceptable without having a gotcha moment. And so that's why I'm offering it. So anyway, that I don't know if that explanation made any sense, but that's what I want full committee to consider and what I want the chairman to review between now and full committee so that he can see the language that I propose to offer. The other things that I propose to offer is in the last section of the bill where it says that in addition to the other 3 sanctions that that discipline shall include termination or something like that, and I propose to change that shall to may so that it becomes a little bit more permissive, not mandatory. And then I also propose to change the original, the $500 second fine after the reprimand for the first offense to $250 and leave the third offense at $1,000. And those were my suggested changes, and those will be presented to full committee unless the chairman and I agree on something else between now and then. But anyway, having said all of that, I will now entertain a motion if the committee so desires. All right, there's a motion to pass. Is there a second? All right, motion is second. Any discussion? All in favor say aye. Aye. Any opposed? It's passed to full committee. Thank you, sir. Is Andy Welch gone? Oh, you're here. That's right. All right. Representative Welch.
Thank you, sir.
Good luck.
Good morning, Mr. Chairman.
All right, Nate. First of all, we understand this is a hearing only?
Yes, sir.
Okay. And you are going to have a whole bunch of witnesses or not?
Just me.
Yay.
Now that I can't speak for the audience, though.
All right, proceed and be brief.
Yes, sir. Many of you may know that the federal government distributes about $16.5 billion in temporary assistance for needy families, TANF funds. The way that this is typically transferred is through an EBT card, which is a debit card, otherwise known as electronic benefit transfer cards, and they work like a debit card. States administer these programs. Back in 1996, there was a welfare reform enactment that was adopted by Congress that had 4 goals. One was to provide assistance, and this is where the EBT block grants came out of, was this 1996 legislation. One is to provide assistance so that children could be cared for in their own homes by their own families. Number 2, the other goal is that end family dependence on government benefits by promoting job preparation, work, and marriage. Number 3, prevent and reduce the incidence of out-of-wedlock pregnancies. And number 4, to encourage the formation and maintenance of two-parent families. And the TANF provision, the block grants, were one aspect of this overall legislation. And they're geared to allow states to administer the funds, the TANF funds, in a manner that is reasonably calculated to achieve the 4 goals. In 2012, the President signed the Middle Class Tax Relief and Job Creation Act of 2012, and that requires states to implement policies and procedures by February 22nd, 2014, that prevent TANF assistance from being used by any electronic benefits transfer transaction, it's using the card, the EBT card, in any liquor store, any casinos or gambling casinos, gambling establishments, etc., or any retail establishments that provides adult-oriented entertainment in which the performers disrobe. Now, the state, if a state has not implemented such policies and procedures and then maintained them so that they're effective, the TANF funds or the TANF block grants can be reduced by 5% for each year that the program is not in place. If you put a program in place and you don't notify Health and Human Services at the federal level, that can also result in a 5% reduction of those benefits. Now, with that being said, the state is still required under federal law to provide adequate access to the cash benefits that are on the EBT cards. When we talk about these EBT cards, the failure to police and prevent the fraud and the misuse of the funds, it really prevents low-income families from having the maximum amount of dollars that they need to support the children that are the subject of the funding. And it also undermines the integrity of the system if these funds are being used to buy beer, alcohol, whiskey, tobacco, gambling purposes, used at adult entertainment establishments. So we're diminishing the public's trust in taking those tax dollars from individuals and then placing them in the needy family system in this EBT block, the TANF block grant, if we're not policing and monitoring how that money is being utilized, especially when it's being utilized in a manner that's, in my humble opinion, not to the benefit of the children or the families. So certainly not in accomplishing the 4 goals that I mentioned to you a minute ago. The department, since this has come to light, and the Department of Human Services here in the state of Georgia has taken aggressive steps in terms of amending its policy, creating new policies, and then sending that information out to EBT card users that have TANF funds on the cards. And those policies, and what I've done is given you a package, so you have a collection of the department's documentation that relate to the policing, the policies they've implemented, and the policing of those policies, and some of the results that are there, which are very positive. And but I have some questions about the data that we have, and I've sent an email with some questions to the department that maybe we'll get some answers to today or at a later date. Nevertheless, what you'll see here, the large gaping loophole in all of this, and that's the elephant in the room when using EBT cards, is the fact that you can withdraw cash from an ATM. Okay, that's what I'm getting at here. So the legislation that you have before you, the bill, what it does in 138, it identifies the federal mandates and puts those, codifies those into law. Secondarily, it has some penalty provisions in there for retailers that breach that requirement. Also, it puts in the standard penalties that already exist for people that are on TANF and abuse the TANF funds. Then, in addition to that, it goes and enumerates, I think it was 13 different uses or services that would not be allowed. It also has some additional, I think, ways to promote the ability to police this, which was placing the 1-800 number. The department has a fraud number already. Placing the 1-800 number and the enumerated items that cannot be purchased with an EBT card or the TANF funds at the cash registers of retailers that accept the cards. And that way the public can do what the public's been doing, and my constituents have been doing with me, is lighting up my phone whenever they see someone using the EBT card and for a purpose they think is objectionable, buying pornography, buying beer. So those kinds of things hopefully that will redirect the calls to the appropriate law enforcement agency to take care of that. Now, so they have some positive data in there that they've seen since the policies have been implemented. I have some questions about it, but I want to point out a few things to you that I think are very important. And that is that even in the reduction of misuse of the policy, of the cards, there are about 18,602 users of TANF funds presently. Out of that, there have only been 283 investigations just last year, 68 established claims. That's 0.3%, 0.36%, or 0.37% actually, of the total sum of users. Yet, when looking back at the data, there were some 1,058 uses of the card to buy alcohol. There were 144 uses of the card to buy tobacco or used in adult entertainment establishments. So the numbers are in excess of 1,000 different uses, and yet we've only got about 200 and some odd investigations just last year. My point is that you've got a large number of uses or abuses of the card, and we have low investigation on the other end. And then bear in mind, now out of that 68 established cases, 30 of them obtained waivers of disqualification. So they were not disqualified, they got a waiver. The rest of them, the 38 remaining, are in a prosecutorial process. So the percentages are even lower in terms of the actual prevention of fraud, abuse, and investigation. There are other states. The other states have what the other states are doing is they're analyzing this. There's at least 12 other states that have done some implemented legislation on this issue. There are about 20 states looking at different ways to address this problem. And one of the things that is being done is that in Texas, they've barred the use of the card at ATMs altogether. And you can do that because there's a bank identification number that's attached to the card, and that can be blocked, essentially, at ATMs. Washington has a kind of a public-private partnership arrangement whereby they're putting the onus on the retailer to block it at their ATMs wherever they're accepting EBT. So that way you're minimizing, you're reducing the convenience at which someone could misuse the card and go extract cash for a purpose that would otherwise be prohibited, or at least otherwise frowned upon by society, and not accomplishing the four goals of the 1996 Act. That's as brief a summary as I can give you on the facts as I know them, and I'm open to take any questions that you have about the bill and about my intentions. I did want to show you that the expansion of EBT in its use has just shocked me over the last year. This is a photograph of EBT cards being accepted at advanced auto parts stores. My concern with this is the proliferation of the card acceptance. And there are only snack foods sold at these locations. And I understand that it would be important to maintain your vehicle so that you can get your children to school. But I'm having some difficulty with the stretch at which this particular card is going. It seems like to me that it is becoming a way for retailers to capitalize on the government program. That's my concern. I'm not saying they're doing it. I'm just saying that that's the suggestion that I'm seeing when you see photographs like this. This was sent to me by one of my constituents just the other day.
All right, let me ask you this. I think that we share your concern as far as making sure that people who have EBT cards are using them appropriately and are able to get the services that they need, but to limit the possibility of abuse. And that's what your bill has addressed. We've heard from banks, from retailers that they don't need to be the policing agency, that that they cannot go in there and physically put an armed guard on every ATM machine or every whatever. So the question is, your bill includes some study stuff, and you've had some discussions with the department. Tell me where realistically you think we can go and how we're going to get there, and then we'll hear from the department.
Yes, thank you, Mr. Chairman. I think realistically, we need the department to investigate with their third-party provider on these cards to determine the best possible means to regulate the use and close that cash loophole. To me, that would be and that's going to involve some technology that may involve separating out the funds and placing them on separate cards, because what's happened is the EBT card is now being the download point for all funds federal, inclusive of veterans benefits, railroad personnel benefits, child alimony benefits, also your SNAP or your special nutrition food stamps is placed on that on the card, and now WIC program is also looking to place money on the card. So you're seeing this one card becoming the central download for all these funds, and there's some governmental efficiencies in that. However, there's also a fraud that goes along with it. And so looking at maybe separating the money out, placing those that should not be utilized for prohibited things, such as trying to take care of children, and not utilizing those funds for pornography and tobacco and alcohol, firearms, bail bonds, spa treatments, gift cards, vacation trips, Six Flags tickets, etc. Those things should be on one card that technology should regulate in some way, shape, or form the use of that money to prohibit its being drawn off of it.
So is your concern primarily TANF and is it food stamps?
And food stamps already have a set of regulations that apply to the use of food stamps. And,
What I'm talking about, but as far as separate cards, child support or an alimony you can use for anything. I presume veterans benefits you can use for anything.
Correct.
So the things that have restrictions on them that would be segregated onto a separate card, if that's the direction the department goes, would be TANF and food stamps?
Most likely, yes, sir.
Okay.
And possibly WIC if that's added.
Okay, so so those are the areas of concern.
Yes, sir.
Okay. All right. Representative Taylor.
Thank you, Mr. Chairman. The shame is that we're sitting here having to have this conversation today. TANF is temporary assistance, and there are families that need it, and when it's abused like this is when we all have a problem, and it is truly all our problems. I don't understand why a TANF or WIC or food stamps should ever be able to access cash. I don't understand why that can't be stopped immediately. And you can program these cards by the code numbers that are on every item that you purchase. We use these in my industry for flexible reimbursements. It knows the difference between a six-pack of beer and a bicycle and medication or covered items. So I'm not understanding why the government can't do what the private sector has been doing. Is there a reason why we have not done it? Is it just an oversight, or has it grown to such a proportion that it's now got everybody's attention?
Representative Taylor, those are incredibly good questions. I don't have the answers to them. I'm hoping that this bill will generate the answers to those questions, if not this session, in the following session.
Does your bill include cutting off all cash advances?
It requires the department to determine the feasibility of limiting or restricting entirely the withdrawal of cash at ATMs or cash machines through the use of the card.
Representative Taylor, to further address that issue, the sponsor and I and the chairman of the committee have had some discussions where rather than, and this is why this is a hearing only, is rather than having a study done, the department's already pretty much into trying to determine what can be done, what it's going to cost, how to best go about to accomplish what needs to be done. And so we're talking about holding this bill for this year, provided that the department will make some very strong commitments that we're going to have answers to these questions by next year, and then the bill will actually define what will and will not be done instead of coming back after a study and still having to deal with the issue. We'll just deal with it one time. And this time next year we will know what can be done and we will, in the all strongest terms, do that. Is that a fairly accurate statement?
Yes, sir.
Okay. Number 26.
I think you used stronger words, though.
Thank you, Mr. Chairman. I just want to say thank you to Representative Welch for bringing this. This is sorely needed. I was just in Sunday school yesterday and had a lady telling me that she had been in Walmart, and a fellow came up to her and said, you know, if you got basically he said in so many words, if you got $100 worth of groceries, let me pay for them, and I'll give you $10 back. You know, he wanted to use a card or some kind of mechanism that he had that he couldn't buy things he wanted to otherwise. So they're going to try to work ways around this no matter what we do, but we got to do the best we can to make sure the assistance is getting to who it's needed to. So I fully support of what you're trying to do, and I thank you for it. It's sorely needed. The one thing I want to mention to you, and you touched on this briefly, I think my goal also would be that we restrict the improper use of the funds that are meant to help people, at the same time put the minimum amount of problems onto the stores themselves that are trying to do legitimate business. And I think you mentioned it somewhere about the display of a prominent sign at the point of sale. I'm imagining the cash register in my mind. And I know that if you walk into a convenience store, their most valuable real estate is right there, sometimes at the cash register, and that space is priceless for them. So as y'all work through this next year, if y'all could work with them to try to make sure that we come up with a reasonable compromise, that we don't confiscate, so to speak, some of their most valuable real estate where a sign in another location might do.
Okay. Any other questions? Okay, and we have Lisa Marie Shekel, okay, from the department.
Thank you, Chairman. My name is Lisa Marie Shekel with the Department of Human Services. I wanted to thank Representative Welch for bringing this much-needed issue some attention. We stand here today as a department to let you all know that we are fully supportive of the intent of this legislation, and we're welcoming the conversation and the dialogue and future action that we will continue to take as it relates to ensuring that these benefits are used for the welfare of our children. I have with me today both our Inspector General, Terry Hamrick, as well as Ann Carter, who is our TANF Program Director. And I'd like, if it is possible, to allow them to provide you with a full update as it relates to the policy changes that the department has enacted since May, and then also provide you with an update as it relates to some of the education that we are taking in terms of allowing retailers to understand what these benefits should be used for. So if I may turn it over to them, I'd like to do that.
And that will be fine, except that before you leave, we want a commitment from the department as to what you're going to do and when you're going to do it.
Well, I think as it relates to what our commitment is, it's to educate people, and it's to find out what technologies we might be able to identify to stop this fraud on the front end. We've already, as I briefly mentioned, updated our policies in response to the Middle Class Tax Relief Act to make it an intentional program violation or fraud to use your card in the stores that Representative Welch had listed. But also, in addition to educating the retailers, we would continue to do that, but we are looking to determine what sort of technology can be put in place to stop the fraud on the front end.
Give us an idea of the options as far as technology.
At this particular point, we believe the best option would be, as Representative Welch had indicated, utilizing the first 6 numbers on the card, the BIN number, which would restrict access to the ATMs in these retailers. We're still attempting to determine what the cost would be. And then additionally, we are in the middle of implementing a new card that would move TANF and food stamps onto, TANF and food stamps off of each other's cards and put TANF on a card with our child support. As a result of these dialogues, I think we're hearing loud and clear that we need to determine if that is the best way to move forward with that contract, and we're exploring ways and trying to determine what the cost would be to have TANF on its own card.
Will we have the answers to those questions in advance of the next legislative session?
That is our goal, yes. We're working with our vendors now to get a full understanding of what that cost impact would be.
I know what your goal is. Is it 90%, 95%? Are we going to achieve the goal by next session?
We'll know.
Understand that my agreement with the sponsor is that he is not willing to hold this bill over
Right.
without a firm commitment on the record of where we're going to be this time next year.
Well, I think as it relates, you do have the department's commitment that we will understand what the cost is going to be, and we will understand very clearly what our direction is going to be, and certainly continuing that conversation with you all here and keeping you informed about what those conversations and what that next action is going to look like.
Thank you. Does that satisfy you, Representative Welch?
It's okay.
Okay. 26, is that you, Barry Fleming?
Yes, sir, Mr. Chairman. I was just going to throw an idea out there. What if we move the bill to full committee today and give them time to get a letter to you and Representative Welch that they are going to do exactly what you asked them to do? That way it'll be in writing. So let's go ahead and move this to full committee, just an idea to throw out there.
Okay. Get me a letter?
We can do that, sir.
Okay. All right, now we'll hear from your witnesses.
Okay.
Briefly.
I'm going to be very brief. Good morning. My name is Ann Carter, and I'm the State TANF Director, and I do thank Representative Welch for bringing this to our attention. Georgia is one of the states that is a very premier state in terms of how we operate our TANF program. So sometimes we're kind of caught between a rock and a hard place because other states say that Georgia doesn't allow anyone to receive TANF, and then now we're faced with, how we are to monitor them. Ever since the bill got passed back in February of last year, the TANF program in Georgia actually went into action. We revised our policy effective May of 2012, and now we have made that if our clients, the TANF recipients, are to use this card in those establishments that have been prohibited, it is called what we call an intentional program violation. So we educate them up front, we meet with them, we explain to them where these places are that they are not to use the card, and then they have to sign off. They have to indicate that I understand what you've said, and I understand that if I use my card in a liquor store, if I use it at an adult entertainment center, that the intentional program violation will be applied. The first offense is 6 months of termination of their benefits, and the second offense is 12 months. And then we'll leave it up to the Office of the Attorney General to tell us if they want to go beyond that point. So we do appreciate what you've done because we do want them to use the monies that have been appropriated for them, that they've gone through the eligibility process to use for their children. So we do appreciate it, and we have taken the necessary actions that we need to take as far as we can go right now. Thank you.
Any questions? Yes, ma'am. Representative Taylor.
Thank you, Mr. Chairman. We're seeing all the things that it's not supposed to be used for, but I'd like you to share with the group, what are the TANF benefits supposed to be used for? I've served on the DFACS board for a number of years in my home county, so I just want to make sure everybody else understands what the money is supposed to be being used for.
Okay, and let me kind of preference just by saying what it is in terms of the TANF program, and I think Representative Taylor, you had mentioned it earlier. The TANF program is a temporary assistance for needy families program, which means that they get cash benefits and support services, because with the TANF program, anyone who receives a cash benefit have to participate in 12 federal work-related activities. If they do not participate in those activities, then their TANF benefits are sanctions, and eventually they are terminated. So, to get to your question, the TANF benefits really are to be used for basic assistance. It is to be used for food, clothing, if they need to take the children to the doctor, transportation, and also what we call incidentals. And I think Representative Welcher had a flyer. Let's say, for instance, you've got a TANF client that wants to go to work, and the only thing that's keeping that TANF client from going to work is a car battery is dead. What the incidentals would do under the TANF program is to send them to the store to buy a battery. That battery would be paid for through the TANF funds, and then that client can go to work. Because one of the 4 purposes that is mentioned is to move them into work, to get them off of cash assistance, since it is only in Georgia for 4 years. So our plan and our purpose is to get them ready for work so that they can become self-sufficient as soon as possible and get off of the cash assistance or the public assistance.
How long does it usually last?
Georgia's largest percentage of TANF recipients is under 18 months. So what I'm saying is any TANF recipient in the state of Georgia receives cash benefits for less than 2 years before they're off of TANF.
When you, I know in the information you've handed out today, it talks about you have to have a child.
Yes.
That's part of it. We've seen great use of TANF dollars. That's really not what my objection is. It's how it's being misused, I guess, is the problem with it. In future, when you're putting together this information, I think that we really do need to look at how and where it's being spent, whether you do it by the stores or the retailers that are using it, or through the codes where they are using it. I do understand, and I've worked with a lot of TANF recipients, and they do use it correctly.
Mm-hmm.
No one is trying to stop that. We want people to be helped. What the problem is when it's abused, and looking for a way to safeguard those that are really in need, and not let the others take advantage and ruin it for everyone else.
I would agree with that. And
Thank
I think one of the other questions that I would like to bring, and I think the question was asked, is why do they need cash? 95% of our TANF recipients do not have bank accounts. And so when they have to pay rent, when they have to pay utilities, they pay those out of cash.
Mr. Chairman and members of the committee, please excuse my voice. Thank you for an opportunity to talk with you today. My name is Terry Hamrick. I'm the Inspector General with the Department of Human Services. We have been working closely with DFACS since they implemented some policy changes last May. And in that time, we have been trying to track data on the transactions that occur on these TANF expenditures. We have targeted locations, specifically baseline locations that were presented to us by another news media group. We've looked at those, we've targeted those locations, and we've tracked the transactions. We have gone out and we have conducted face-to-face visits with these retailers to make sure that they understand the types of expenditures that can be made with the TANF funds. We have had an aggressive mailing campaign out to retailers of some of these unauthorized retailers specifically, but we are looking for ways. Our commissioner and our department, as all of you, are very concerned about the misuse of TANF funds. We are constantly looking for ways to pursue those who misuse those benefits. We can expect to continue this effort as we gain more momentum with changes in our technology and our ability to track these transactions. We do expect to make progress in this area. If you have any questions, I'll be glad to answer those for you.
Are there questions? Hearing none, thank you.
Thank you,
sir. Representative Welch, I'll give you the last word. Oh, I'm sorry, Kathy, you wanted to speak. Kathy
Thank you,
Kazava.
Mr. Chairman, members of the committee. My name is Kathy Kazava, and I'm the president of the Georgia Food Industry Association. I had told the chairman that I didn't believe I was going to speak today because I've got written testimony for all of you, and I know the best lobbyist is be brief, be bright, and be gone. So I will do that, and I have written testimony for you. I just wanted to go ahead, though, and respond to some of Representative Welch's comments so that you could understand exactly what we do in the supermarket industry. I represent the independent grocers, everything from the IGAs, the Piggly Wigglies, on up to the Food Lions, Harveys, Kroger's, Publix's of the world. And we are very, very concerned about any kind of misuse in government funds. And a lot of what we do at the store is implement some of the programs that the federal and state partners come up with. And I just wanted to make sure that we make a little bit of differentiation in some of the programs. The SNAP program is the Supplemental Nutrition Assistance Program. That's the food stamp program. And that program is not TANF at all. That program is very, very well defined as to what we can and cannot take as far as when a customer comes in. Anything that's non-food is not eligible for TANF, or for SNAP rather. So clearly tobacco, alcohol, anything like that, as well as everything from toilet paper, vitamins, etc., is not allowed on SNAP. WIC is very, very defined, and WIC has got a federal mandate by 2020 to go to electronic, we call it e-WIC, because it really does, believe it or not, I know this sounds crazy when we're talking about all this, but it really does, going to the electronic benefits program, reduce fraud in a huge way. But there is still so much more that we could do. TANF, and the reason this gets more complicated, is that TANF is a cash benefit. And right now, anytime that there is a cash benefit on that card, there are no restrictions for cash benefits because they're cash. So years ago, the state used to send out a check to the individuals for their TANF or their child support or whatever, but let's talk about TANF right now. They would send a check to that individual. The individual would probably, because like you heard, 95% are unbanked, would have to go to a check cashing facility, and maybe not in the best neighborhoods, and usually having a pretty high cost to cash that check, so that then the recipient would be able to use that benefit for whatever, whether it be rent, whether it be to fix their car, whether it be for additional groceries. What's happening now is when people see EBT, and I know my grocers call me and say, Kathy, how in the world can a like the auto zones, how in the world can they take food stamps? And they start, because half my grocers still call it food stamps. How can they do that? That is not right. And I have to remind them that EBT does not equal food stamps or SNAP. EBT is just the method of delivery for benefits that the state and local governments have provided. So we have to remind them of that. And a lot of times when people see, and a lot of times when your recipients will see EBT accepted here, they're thinking fraud. Somebody is committing fraud. Somebody is trying to sell their food stamp benefits, because they're going to still say food stamps, in that auto dealer's store. And that's not the case. They can use that TANF or that cash benefit to purchase anything in that store, whether it be the new battery to get to work, whether it be a candy bar, whatever is there, because it's cash benefits. So I guess we're not here as grocers to discuss policy at all. You guys make the rules, the feds make the rules, and then we carry them out. But as grocers, and as someone who really understands how a front-end system works, I just ask you to be cognizant of, when you make rules, whether or not they can be enforceable. For example, let's take a public store. If you go in right now, Representative Welch's bill calls for that no TANF benefits can be used through an EBT, POS, ATM, anything, or any other means. Well, if you go into a public store and you're a TANF recipient and you come in the door, even if we had restrictions that said you couldn't buy a bottle of wine, it's cash benefits. So if we had our registers programmed, if we had signs up, if we did everything that sounds good, and it really does sound good, if we did everything like that to prevent a customer, all they have to do is go to the ATM, get $20 out, and they can buy whatever. They can buy vitamins, they can buy a bottle of wine. We have no way of knowing. So I'm afraid that it is a very, very good intention, but it's just unenforceable. So that's what I would ask, and I talked to Representative Welch, and I would like to offer all of you my years of expertise, not that I'm an expert in much, but I do know front-end systems, and I really do. TANF is such a small portion of what we see as far as fraud going on in our system, and if we really want to discuss fraud, if we really want to pay attention to what is unbelievably going on out there, it's what Representative Fleming talked about. It's the food stamps. It's the SNAP benefits that are unbelievably more of a program than this small TANF program. But that's what's going on in much more of a way. So I just ask you that as you look at this, and again, I'm sorry I've gone too long now, but I've presented testimony with where our grocers do have a problem with some of the language, because it just goes on. We just don't believe it's enforceable. But we certainly do anything we can do to prevent the fraud. We are there because we're the bottom line. We are taking care of the customers and handling their food when people make decisions to do so. Then we're the ones who take care of the customers. And with that, I'd answer any questions.
Are there questions? There aren't any. Thank you.
Okay.
Any other witnesses? All right, Representative, last word. It's getting to be lunchtime.
Yes, sir. Very quickly.
Wait just a second. Representative Fleming? Okay. All right. Go ahead.
Yes, sir, just very quickly. You know, when I came to present the bill, I identified the gaping loophole, which is ATM. So the bill attempts to try and force the department to rectify and look at the bin numbers as a way of stopping that. And several states, and I included in my package a table that has a list of all the states that are now currently either considering or have statutes on the books regarding restriction of public assistance or EBT card use. So this is going on across the United States, where states are tightening down on the use of EBTs. And so the enforceability is apparently there because a number of states are engaging in the activity. Furthermore, I'd like to point out, I'd like to ask Ms. Kusala the question. She pointed out that the SNAP program is very well defined, and that when you go to purchase an item, there is a mechanism by which tobacco and alcohol are blocked from being purchased. Why not the same for TANF? That's all I have to say. Thank you.
All right. Representative Fleming.
Mr. Chairman, for the purposes of allowing the department to have time to get a letter together to give to Representative Welch and the chair, I would move due pass on this bill to the full committee.
Is there a second?
Second.
There's a motion and a second. Any discussion? All in favor say aye.
Aye.
Any opposed? The bill is moved to full committee, subject to us receiving a letter from the department giving us some specific deadlines, commitments, and the like. And if that in fact is received, then it will probably be held in abeyance. We'll not move any further. But if not, we can move it further. Thank you. And we had one other bill on the calendar.
Thank you.
But we are not going to get to it today for several reasons. Number one, the sponsor's not here. The sponsor's designee is not here, and it's lunchtime. And this room is only reserved till noon, and so we will be in adjournment. But if you will contact Craig, we will go ahead and try to schedule another meeting this week, so that, because we realize we're running up onto the 30th day. Okay, thank you. We're adjourned.